Despite the Supreme Court ruling, New York continues to turn gun laws upside down. I'm here with noted criminal defense attorney Tom Grieve, but first, we have a super secret giveaway going on right now, but it ends really soon. If you want to enter for your chance to win this long distance hole puncher absolutely free, click the link in the description down below. Tom, now it's a felony if you carry your gun into private property in New York, whether it's posted or not. What is going on in your estimation?
Yeah, so let's kind of start out with the way it works in almost every place not named New York.
Let's call it the civilized world.
The civilized world, right. Yes. In the civilized world, so there's something called sensitive locations, right? Like a courthouse.
Yeah.
Post office.
Jail.
Jail. Cannot bring firearms to sensitive locations, okay? If you're mailing a firearm, okay, there's exceptions, but let's not ruin this, right? So you cannot bring firearms into sensitive locations. Check. Everywhere else, that's private property. A mall, a movie theater, whatever the case may be, a restaurant, you can generally carry unless it's prohibited. Okay.
By the owner. The owner has the right to prohibit you from carrying a gun on their property.
Right. And they post signs. There's a signage requirement and so forth. And again, obviously the list of sensitive locations is longer. It does vary from state to state. So check your local listings. But that's the gist to it. Private property that's not a sensitive location is lawful to carry in unless it's posted saying you can't. Check. New York has flipped this upside down and saying, you know what? It's illegal to carry everywhere, unless you post that it's lawful in a non-sensitive location.
And unless you have express permission from the property owner, they post a sign that says, yes, your guns are welcome, and then it's legal. And we just read this. It's a felony. This is a felony if you carry your gun into a place that has not given you permission to carry it in there.
I mean, they really like disarmed victims. Like, I don't know what to tell you. This is fetish level territories that we're hitting.
Because we're talking about the concealed carry laws, which are allowing people to defend themselves, which by the very nature of the rules and the laws, it is the honest citizens who are jumping through all the hoops, overcoming all the barriers to entry to get their permit, to get their training, to legally carry a gun to defend themselves. And then the state of New York says if you take it into a place that doesn't give you express permission before you get in there, you're committing a felony.
It's a felony. I mean, it's a complete inversion. In my estimation, I'm getting on my soapbox here, but it's a complete inversion of who's the defendant, who's the victim here.
Yeah.
Because the bad guys, they're not going to pay attention to this anyway.
No, absolutely not.
That's part of why they're bad guys.
Yeah.
Right? So all you're doing is ensuring that as many people are disarmed as possible, which flies directly contrary to the spirit of New York Rifle State Pistol Association v. Bruen, the massive landmark U.S. Supreme Court case that came out in June of 2022.
So as we go through this Supreme Court case, and I don't know if it's just a case of unintended consequences, where suddenly the Supreme Court says, yes, concealed carry is okay. You don't have to prove your need. Just the fact that you want to defend yourself is your need to concealed carry. This seems to have opened up just a flood of new attempts, and I'll call them attempts, to put further barriers in between honest citizens and concealed carry. And I can see this one going to court, and I've seen other cases. There's injunctions, there's TROs. They can't enforce some of this stuff. But everything we've looked at, we can't find any ruling that says, nope, we got to stop this.
I mean, it's super fresh. So that's one particular aspect. I mean, basically, they are setting the needle on this is a felony unless private business owners and private property owners opt away from that.
Yeah, it gives you express permission.
I mean, if we imagine the government saying that, free speech is illegal unless a particular location opts into it or something like that. I mean, that's an imperfect comparison, but it's something like that. I mean, that would be some sort of bizarro world.
Yeah,
right?
well, one of their sensitive locations was you can't carry a firearm to a location where people are gathered to protest for their constitutional rights.
Right.
So if you went to a Pro-2A rally, even though you were legally permitted and followed every other law in New York, you can't carry a gun at a Pro 2A rally.
And a reading of the New York State Q&A, official Q&A government PDF that we downloaded and we both reviewed, we can take this another step further. Like, you want to get nuts, like Michael Keaton style, let's get nuts, all right? Yeah. It would seem that you could be on private property, like in someone's yard or something like that, not even like on a sidewalk. You could be on private property protesting, holding up signs in favor of the expansion of Second Amendment laws. And even though you're in private property, but because it's a constitutional rally that you're at,
it's a gathering.
It is now a sensitive location, right? Because it would, and again, at a minimum, that argument is out there.
Yeah.
From reading what you and I both read, which was put out by the New York State authorities, right? That is the way that this goes. So that is pretty nuts in the scheme of things. And let's just kind of briefly restate for anybody who does not know, what did that June 2022 New York Rifle State Pistol Association v. Bruen, what it explicitly did, and then it went on to do a couple other things. It explicitly basically said, look, may issue is not a thing. If you meet the criteria and if you apply for a concealed carry license, governments shall issue you a concealed carry permit. Okay.
You don't have to prove your need.
You don't have to prove your need. You don't have to do any of that kind of stuff, right? What it also went on to do is to say that as long as you are adult, you're not a prohibited possessor, you're carrying an ordinary firearm to a non-sensitive location, you should be able to conceal carry. Okay. Now, again, leaving plenty of room for private property rights and all that kind of stuff. Okay. But that's some pretty big canonical things that the Supreme Court came out with. But that's not even probably the biggest in my view. The biggest in my view is the fact that they finally put down the test for how all other courts are supposed to assess any sort of law that goes to the heart of a Second Amendment issue. In other words, any sort of firearm regulation law or something like that that is cutting to the core of the Second Amendment. So there's all sorts of different levels of scrutiny that we talk about, strict scrutiny, rational basis test, interest balancing, all that kind of stuff, okay? And the gist to it is this, right? Because nobody has the patience to sit through like a 5-hour legal seminar. The gist to it is this, is that what the Supreme Court said is, look, we're not doing some sort of very low test. In other words, a very low bar that the government has to clear in order to pass a Second Amendment law, which, by the way, every other constitutional amendment has a strict scrutiny analysis, which is the highest bar that government must pass. But basically, the Second Amendment was the only amendment that had a pretty low, arguably a rational basis test to it or something like that. Again, I won't bore you on the details. If people want that, let us know in the comments. We can get into that another time. And instead, what they instituted is basically a traditional history and historical analysis of, look, you have to show that the firearm laws that you're passing come from the breadth of both American and, prior to that, English common law tradition to show, look, we aren't coming up with something new and crazy out of left field here. This is something that's been going out there for 100, 200, 300, 400 plus years. It is part of the American and, prior to that, English common law tradition, and the law that we're passing and the regulation that we're passing is consistent with that tradition. So it's basically a historical tradition analysis. And if people want to know, guys, if you want to know what some courts have already tried to do to sidestep that analysis, post it up in the comments. I'd love to be able to get to that if it's something you're interested in. And if you're interested in knowing more, of course, about this particular analysis, we can get it another time. But the reason why that's so important is because the court has set a very high bar now for all sorts of firearm regulations, every firearm regulation that goes to the heart of the Second Amendment where it has to cross. And prior to that, they had a very low bar to clear. Now they have a very high bar to clear. That is going to have such lasting impact for generations to come as far as protecting the Second Amendment. And unfortunately, if you're not a law nerd or something like that, it's really difficult to understand how important that is. But in essence, the Supreme Court raised the walls around the city of the Second Amendment to where they ought to have been. They've done it in a reasonably unique way. rather than just the wide open front gate and the 2-foot wall, and every single regulator and every single legislature could just come on over and dump whatever they wanted.
And absolutely, this shows elections have consequences. And if you're not politically active now, folks, get politically active, because this Supreme Court case was not the end. It was the beginning of lots and lots of challenges for anti-gun folks to step up and say, well, maybe we can do it this way. And they just keep coming. Thanks again, Tom, for the insight. Love it. I really appreciate your help on this one.
No problem. I also add that I go into some of this analysis on my own, very USCCA-friendly channel over at my name, Tom Grieve.
Alrighty. Thank you.
Thanks.
You're pulled over by the police and you're carrying concealed. Do you need to do anything special in this scenario? Like tell the officer you have a gun. Click this video right next to me and I'll break down that scenario step by step on what you should do.